a legal challenge against creditors accused of abusive practices could drastically change the South African credit market. The University of Stellenbosch Law Clinic and Summit Financial Partners filed court papers at the Western Cape Court, that's of course the High Court, against lenders who take advantage of desperate debtors by racking up unlawful fees. Joining us via Skype on this particular conversation is Clark Gardner. This is of course on the phone. That's Clark Gardner, the CEO of Summit Financial Partners. Clark, good to have you on the show. Is this a case of sheer customer oblivion, or is there a case to start with?
I think there's a combination, one of a sophisticated, ambitious collection industry who are preying on a financially ignorant mass market where justice is not really easily accessible. And I think, we're trying to bring back that balance in this collections game and the collections industry to stop the abuse that's therefore been allowed to happen.
Right, Clark, let's talk about the fact that maybe there could be some fallback here, maybe some pushback. Do you get the sense that some listed companies here might feel the wrath if this ruling goes against them, or in your favor, should I say?
No, look, I think in the listed space, this is a very small part of their book, and very few of them. I know the top 4 banks do not use emolument attachment orders in order to collect on defaulting unsecured debt. I think this is more about the collectors and those legal firms, mainly small law firms who are location-based, to small areas. And they're the ones that have been, for instance, a law firm in Rustenburg. They're the ones that have added really unacceptable amounts of fees in order to collect and justify their existence. So, for instance, Stain Attorneys is one of the respondents. They collect on 500, 600 Rand to maybe 5,000 Rand unsecured debt, and they ordinarily charge 4 to 5 times that in collection fees and legal fees and so on.
Clark, my Latin is a bit rusty here, but I'm going to go for it. There's something here about the duplum, which is, of course, already in the Constitution here, the National Credit Act of 2007. One might argue that the framework is actually there, at least the legal framework, not to have legal costs and outstanding fees that are double the principal. How is this being evaded to start with?
Yes, so as I say, I mean, the law is as good as it can be enforced, and the law is very specific in both in Section 103 and Section 101 of the National Credit Act. We refer to it as the duplum rule, but that's not accurate. That's a common law rule which had a similar statement, although this is far more bulletproof. And what it states is that on default, you cannot be charged more interest and fees, and in those fees include collection costs, more than the capital outstanding at the time. And what we're seeing is that that's disregarded because of the financially ignorant consumer and the difficulty to defend a case when you are a financially ignorant mass market employee who perhaps works underground for 10 hours a day. You don't know how to fight this. You don't know how to access justice to defend yourself. And we've got collectors here charging 4 to 5 times the capital outstanding when they collect via court. So it's just abuse. Again, the law is very specific, and we were amazed that we had a case similar to this in Mafeking where even the law societies opposed us because this is their bread and butter. This is how their members make money. And let's not forget that Bob Roth was chairman of the Northern Law Society. These guys are not good people. They are there to abuse the mass market. And even the GBC, the General Bar Council of South Africa, opposed us. Nedbank opposed us. So I think people just forget in the sophisticated financial services industries the consequences of their actions and how we are hurting families and really taking food off the table of these people that only had a 500 Rand unsecured debt and end up having to pay 10, 15,000 Rand back as a result of these legal fees being so unscrupulously added.
Clark, very briefly before I let you go, 49 respondents here, of course, including major banks and financial institutions, are actually on your side. What does it say about the system as it is? Very briefly.
Look, I think the whole point is that the system is unbalanced. We have a highly sophisticated deep pockets of lenders and collectors, and we've got consumers that really don't access any justice. And the main reason for that is that there's a lack of a proper, effective referee. When capitalism is not refereed, that's when chaos prevails. And at the moment, these consumers aren't being looked out for. The bodies that are allocated to do the job is not doing the job. And we have very, very sad stories as a result, and a disempowered consumer who's severely prejudiced. And our job is to now bring balance back into that equation and protect these consumers from the abuse taking place.
Without a doubt, a few good men doing nothing is what it takes for evil to prosper. A very noble cause, exactly, if you ask me. Clark, many thanks for making time to speak to us.